everyone. Welcome to LawSikho's thorough newspaper analysis for 24th Feb 2023. Starting with the editorial section of today's session, case that scans the working of the anti-defection law from The Hindu, writes at the center as well as from The Hindu, followed by the news update and the legal news. Starting with the first editorial session, a case that scans the working of anti-defection law. A five-judge bench of the Honorable Supreme Court of India is presently hearing a set of cases popularly known as the Maharashtra political controversy cases. Recently, Election Commission of India ordered that Eknath Shinde's faction is entitled to the Shiv Sena party name and symbol. The anti-defection law was introduced in the Constitution of India via 10th Schedule 1985. The 10th Schedule sought to put a stop to this by stipulating that if any legislator voted against the party whip, he or she would be disqualified from the House. While on the one hand, this empowered party leadership against the legislative backbench and weakened the prospect of intra-party dissent. This is where the role of Honorable Supreme Court of India becomes crucial. Disputes over government formation and government toppling invariably end up before the highest court. It must immediately be acknowledged that such cases place the court in an unevitable position. The court has to adjudicate the actions of a number of constitutional functionaries, government speakers, legislative party leaders, elected representatives, many, if not all of whom, it put it charitably, have acted dubiously. The present case, that is the Maharashtra political controversy case, that presents an interesting case study. It began when a set of legislators from the Shiv Sena rebelled against then CM Uddhav Thackeray. The deputy speaker, there was no speaker at that time, moved to disqualify the rebels, who in turn moved the court, arguing that there was a pending no confidence motion against the deputy speaker, and therefore, as per the Honorable Supreme Court judgment in Namam Rabia case, he was disqualified from deciding on the disqualification while it was pending. The Honorable Supreme Court vacation bench stayed the deputy speaker's hand but also directed a floor test. The upshot of this was that the rebel MLAs, who may or may not have subjected themselves to disqualification, were able to vote in the floor test and voted to bring the government down. The new government was swiftly sworn in by the governor and appointed its own speaker, thus effectively creating a fait comply with respect to pending disqualification petitions. To top it all, the Supreme Court orders were interim in nature and therefore no reasons were provided. The court's judgment can act as a counterweight to political power and infuse a dose of constitutionalism into the politics of government formation and toppling. But equally, the court's judgment could make toppling government even easier for those with the means to do so. Only time will tell which of the two it will be. Coming up to the second editorial section, writes at the center. In 1959, the United Nations General Assembly adopted the Declaration of Rights of the Child, the first charter of its kind ensuring basic rights of all children below 18 years. With this word, mankind owes to child the best it can give. Yet, as is well documented, children, because of their vulnerability, often become victims of abuse of power by the very people who are entrusted with their protection. Leaning on child's fundamental right to privacy, the Supreme Court of India has ruled that children cannot be mechanically subject to DNA tests in each and every case between warring parents as a shortcut to establishing infidelity. Directing courts to acknowledge that children must not be regarded as material object and that they be subject to forensic DNA testing only as a last resort, particularly when they are not parties to a divorce proceeding. Justice Nagaratna observed that it is imperative that children do not become the focal point of battle between spouses. While this is a welcome move, a reading of 1989 United Nations Convention on the Rights of Child shows that there are miles to go before every child in India is guaranteed special care and assistance. India ratified the convention in 1992, and over the years, several laws have been enacted to protect the rights of children, though their implementation has often been dodgy, failing to shield them from abuse, violence, exploitation, or neglect. Coming up to the news update, UAE to host first I2U2 Business Forum meeting held in Abu Dhabi. The I2U2 Business Forum aims to become a regular platform for private and public entities from the four countries to establish tangible joint business ventures in economic and technological fields. The I2U2 grouping focuses on driving economic cooperation between its members in sectors such as food security, water, energy, space, transportation, health, and technology. The I2U2 group is a grouping of India, Israel, the United Arab Emirates, and the United States. Asked Shelley Oberoi elected as Delhi mayor. As per the provision, the MCD has to elect 5 mayors in 5 years, starting with a woman. In the third year, an elected councillor from the scheduled caste will get the post. Coming up to the third news update, 18th World Security Congress begins in Jaipur. The 18th UIC World Security Congress, jointly organized by International Union of Railways, Paris, and the Railway Protection Force. The theme of the year's Congress is Railway Security Strategy, Responses, and Vision for Future. The Union International Desk Chairman, that is UIC or International Union of Railways, established in 1922, is headquartered in Paris. Coming up to the next news update, INS Sumedha visits Abu Dhabi to participate in IDEX and NAVDEX 23. INS Sumedha is the third ship of the indigenously built Saryu class naval offshore patrol vessels. INS Sumedha, built indigenously at Goa Shipyard Limited, she is fitted with an impressive array of weapons and sensors. Coming up to the next news update, Cabinet extends term of 22nd Law Commission until August 2024. The Commission is a non-statutory body constituted by the government from time to time to make suggestions on reforming existing laws and promoting good governance under the rule of law. Former Chief Justice of the Karnataka High Court, Ritu Raj Avasthi, is the chairperson of the current commission, and its members include K.T. Sankaran, a retired judge of the Kerala High Court. The first law commission was established during colonial rule in India by the East India Company under the Charter Act of 1833 and was presided by Lord Macleod. After that, 3 more commissions were established in pre-independent India. The first Law Commission of Independent India was established in 1955. Law Commission has been instrumental in the progressive development and codification of law in country, and the Commission has so far submitted 277 reports. Coming up to the 6th news update, Pandit Prem Kumar Malik bags for the Sangeet Natak Academy Award 2019 for contributions in the field of music, that is Hindustani vocal. Sangeet Natak Academy Award, also known as the Academy Puraskar, is an award given by Sangeet Natak Academy, India's National Academy of Music, Dance and Drama. It is the highest Indian recognition given to people in the field of performing arts. Coming up to the next news update, government asks all state UTs to make 6 years minimum age for class 1st admission. Students can be admitted to class 1 only at the age of 6+ years instead of the earlier practice of 5+ years, the Education Ministry told states and union territories. Until the new education policy 2020, children in the age group of 3 years to 6 years were not covered within the 10+2 structure of formal schooling. Under the new structure, children aged 3 to 8 years come under the foundational section, including 3 years of preschool and 2 years of primary school, followed by preparatory, middle, and secondary sections in 5+3+3+4 formula. Coming up to the legal updates, different pay scale for seemingly similar posts justifiable if there is a reasonable classification by Honorable Supreme Court and Union of India versus Indian Navy Civilian Design Officers Association and another. Pay commissions may be justified in recommending different pay scales for seemingly similar posts, and if the state accepts such differentiation based on a reasonable classification, then court will not interfere. The doctrine of equal pay for equal work will not strictly apply in such cases. The equation of post and determination of pay scales is the primary function of executive and not the judiciary. The relevant article of the Constitution of India relates to this particular legal update is Article 39, subclause T, that provides equal pay for equal work for both men and women. That is equal pay for equal work for everyone as between the sexes. Coming up to the last legal update, mens rea essential element under Section 344 Criminal Procedure Code by Honorable Chhattisgarh High Court in the case of D.R. Thakur versus State of Chhattisgarh. criminal proceeding initiated under Section 344 of the CRPC against a Tehsildar for allegedly giving false evidence in a trial court. The court observed that mens rea is an essential element under Section 344, and thus it is required to ascertain whether the witness had knowingly or willfully given such evidence. Stay tuned for more updates. Thank you and take care.